The most frequent question I am asked from readers of this website who have creditor problems is, should I file bankruptcy or should I continue to defend my collection in state court? Hi, I'm Jonathan Alper, and I'm a bankruptcy attorney and asset protection attorney practicing throughout the state but located in Orlando, Florida. Bankruptcy should be your last resort to protect yourself against creditors who are trying to enforce a judgment against you. And here's why. In bankruptcy, you actually have less exempt property and less protections than you do outside of bankruptcy in state court. Let's look at two examples. First, the best known example is your homestead exemption. In state court proceedings, everyone who is a Florida resident has an unlimited homestead exemption regardless of the value of their house. And the homestead exemption is applicable immediately after you purchase and move into your house. In bankruptcy court, if you choose to file bankruptcy, your homestead exemption is limited, much more limited than the unlimited exemption in state court. For example, in bankruptcy, you do not get the full unlimited Florida homestead exemption unless you have, number one, lived in Florida for 2 years, and secondly, have acquired your interest in your house more than 240 days prior to filing bankruptcy. For many people who have recently come to Florida or recently purchased their house, that's going to limit your homestead protection in a bankruptcy proceeding. Also, in state court collection proceedings, if you invest a substantial amount of non-exempt cash to either buy or improve your homestead, a creditor cannot challenge that as a fraudulent conversion designed to protect your money. Not so in bankruptcy. In a bankruptcy proceeding, if you take a significant amount of non-exempt property and use that to invest or improve in a homestead property within 2 years of filing, or in some cases up to 10 years before you file, a bankruptcy trustee or one of your creditors can challenge that as a fraudulent conversion designed to defraud your creditors and the bankruptcy court. Secondly, another area where you have less protection in bankruptcy is in what's called tenants by entireties property, or the layman's definition is marital property. Property owned jointly by a husband and wife is exempt in state court proceedings for collection as long as the judgment is against only one spouse individually. That marital property exemption is unlimited in a state court collection. Again, not so in bankruptcy, because in bankruptcy court, if these two spouses, the debtor and non-debtor spouse, have any joint unsecured debt, that's not mortgages, we're talking about joint unsecured debts such as credit cards, medical debt, taxes, student loans, etc. Any of those joint unsecured debts can forfeit your tenants by entireties protection, which is afforded to the debtor spouse outside of bankruptcy. So what's the conclusion to reach using these comparisons? Well, I'll tell you what I think the conclusion is. I think the conclusion is avoid bankruptcy at all costs and file bankruptcy as a last resort only. I have found over many years of practice that people with low incomes and people who have accumulated relatively few assets other than retirement plans often are able to solve their creditor problems in bankruptcy. But people who are high income earners and who have been fortunate enough to accumulate businesses and stocks and bonds other than retirement assets don't do very well in bankruptcy and must avoid bankruptcy at all costs. If you have a creditor issue and you are considering whether or not you need to file bankruptcy, give me a call. My name is Jonathan Alper and my phone number is 407-444-0404. I'm here to help you. And thanks for watching.